Professor Angela J. Davis, author of Arbitrary Justice. Why do you say in your book that the prosecution is the most powerful branch in the judiciary?
Because prosecutors actually control our criminal justice system, I believe. They are the most powerful actors, most powerful officials in our criminal justice system because they make the charging and plea bargaining decisions in the criminal justice system, and those decisions are the decisions that really drive our criminal justice system. Most people think about police officers, being sort of the first people that, introduce individuals to the criminal justice system, and for the most part, that's true. And police officers have a lot of discretion in who they stop on the street and ultimately who they arrest, but they only bring individuals to the courthouse door. It is the prosecutor who has the power to firmly entrench individuals in the system or not, because once a police officer brings an individual to the court, to the prosecutor then is the person who decides whether that individual will be charged with a crime and what those charges will be. Even if there is probable cause to believe a person committed a crime, even if that prosecutor believes that he or she has proof beyond a reasonable doubt and can prove that person's guilt at trial, they are not required to charge that person. They can decide at that point to simply drop the charges, or they can decide to go forward. And they have a lot of discretion in deciding what to charge that individual with. And they're accountable to no one but themselves. They don't have to justify bringing charges. They don't have to justify dropping charges. And there's a lot of discretion in what they do. So, for example, if a police officer arrests an individual for possession of cocaine, and let's say the individual has a large amount of cocaine in their possession, 2 kilos. With that amount of cocaine, a prosecutor could charge an individual with possession with intent to distribute cocaine, which is a felony offense that carries a lot of time in prison and possibly even a mandatory minimum period of time in prison that person would have to serve. They could charge that. But just because they have the evidence to charge that, they don't have to. They could decide, well, I'm just going to charge this person with simple possession, which is a misdemeanor that carries a year in prison at most and possibly probation. And so that's a lot of power to put in the hands of one person. And the concern I have is that when that discretion and power is not used in an equitable and fair way, when there are individuals, similarly situated in terms of what they're alleged to have done, what their criminal history is, and prosecutors treat one with a certain favoritism and another they don't, then that's when you get unfairness in our system. And prosecutors, unlike any other official in our system, they are not as accountable, in my view, to the public that they serve. Police officers do what they do in public space. We see what they do. Judges are in a courtroom when they do what they do. Prosecutors make these charging decisions and plea bargaining decisions that they make behind closed doors. And it's very difficult, in my view, for the public to hold them accountable if they are doing those functions in ways that produce inequities in our system or in ways that produce unfairness, racial disparities, and so on. And so that is my concern about prosecutors. We need prosecutors in our system. They are important. They enforce the law. But we need them to do it in a way that's fair, and we need to figure out how to hold them accountable, because a lot of their actions can and do produce injustices in our system.
Professor Davis, is their power institutionalized in law, or is it just developed over the years?
It's interesting. The idea of prosecutors, the system of public prosecution, started right around the time of Jacksonian democracy, when we had this view that we wanted to vote for people and hold them accountable. The whole idea of democracy is that the people choose the individuals to perform these functions. And so when we started to get this public prosecution, because in the past there used to be private prosecutions, private individuals were able to, bring charges against other individuals and they had to pay for it. That didn't last very long. We ended up with this public prosecution system, and we ended up with elected prosecutors for our state and local systems. So All of our states, except about 4 of them, have elected officials for their state and local prosecutors. Our federal prosecutors are appointed, but state and local ones are elected officials. And that electoral process is supposed to be the way that we, the people, hold prosecutors accountable. The problem with the system is that because there's no transparency in the most important functions that prosecutors perform, namely the charging and plea bargaining functions, it's pretty hard for the electorate to hold them accountable. When most prosecutors run for office, for example, on the state and local level, they don't talk about, well, here are my charging policies and here are my plea bargaining policies. I don't think most people even know what those terms mean. They speak in very general terms. You know, I'm tough on crime, and then their opponent says, I'm tougher on crime, and that's really basically what the public has to choose from without any discussion about the most important functions that they perform. And so that is my concern.
Would a defendant's lawyer not be allowed to be part of that or to hear the deliberations of the prosecutorial team?
Absolutely not. So, for example, I spoke a bit about the charging function. It's hard for me to talk about that without also talking about plea bargaining. And defendants are involved and defense attorneys are involved in the plea bargaining process, but not in a way that gives them very much say-so, and I'll explain why. So I talked before about the charging function. Well, very closely connected to that is plea bargaining. We have a system of justice where I think most Americans think that there are all these trials going on in courtrooms, in criminal courtrooms around the country. They watch Law and Order and they see all these television shows and there are all these trials going on. Well, there are more trials going on in TV shows probably than there are in real life. We don't have a lot of trials going on, but we do have a lot of guilty pleas. About 95% of all criminal cases are resolved by way of a guilty plea, not a trial. And the way it works is this. The prosecutor will bring the charges. As I mentioned before, the prosecutor has a lot of discretion in deciding what to charge. And my example I gave before about the cocaine, for example. That prosecutor can charge a felony, but if they want to, they can charge a misdemeanor. There's also a phenomenon called overcharging, where prosecutors pile on charges because it's very easy to bring a charge, right? All the prosecutor needs is probable cause to believe that the person committed the offense. That's more likely than not. That's a very low standard and far lower than what they would have to prove if the case went to trial, which is, of course, proof beyond a reasonable doubt. So prosecutors, some of them will bring lots of charges, even knowing that some of them they won't be able to prove at that higher standard, and they do that so that they're at an advantage in the plea bargaining process. So if there are 5 charges, for example, 5 felonies, the prosecutor can go to the defense attorney and say, I'll allow your client to plead to one of those felonies. If he pleads guilty to one, I'll dismiss the other 4 if he agrees to plead guilty rather than going to trial and exercising his right to a trial.
So kind of a negotiating?
It's a negotiating thing. And I, as a defense attorney, can come back and say, well, how about if he pleads to one misdemeanor rather than one felony? And it's a back and forth. But ultimately, the prosecutor has the last word. The judge has nothing to do with it. The judge can't step in and force anybody's hand. It's up to the prosecutor. And they don't even have to make a plea offer if they don't want to. So they're holding all the cards in that situation. Even though there's a negotiating, they have the power there. And so that's what the defense attorney can do. Now, that happens in many more cases than not. We have far more pleas in our system than we do trials. And I don't think there's anything wrong with plea bargaining. It certainly benefits all sides. It benefits the defendant. For example, if he's actually guilty of all 5 of those charges and he's given an opportunity to have 4 of them dismissed and only plead guilty to 1, that's going to be a better result for him than going to trial, risking going to trial and having a jury come back and find him guilty of all 5. Obviously, it's going to benefit him. And it benefits the government, the prosecutor, because it saves the system a lot of time and money rather than going through a trial that's expensive, that lasts for days. They go into court, the guilty plea is over in 15 minutes, and it moves the cases along. So there's a lot of people in the plea bargaining system that benefit from that process. If it's fair. It's not fair, for example, if the prosecutor makes a plea bargain with the defendant, but doesn't tell the defendant all the evidence.